Hey there, I'm Paul Rabelais, and in this video we're going to talk about part 3 of 8 parts, how to leave it to the kids. So in part 1 it was all about the lifetime gift. Part 2 was about the common and traditional outright bequest. This one is really gets kind of popular when people find out about it. It's the leave an inheritance to your child in a trust with your child as the trustee. All right, so what I'm going to go through is how that gets done, the reasons people do it, the consequences of doing it that way, and then we'll wrap it up with a summary. So, oh, by the way, I'm Paul Rabelais. I'm an estate planning attorney. I help our clients get and keep all their estate legal affairs in order. Make sure you subscribe, hit the red button, hit the notification bell, and if you like what you see, just punch the thumbs up button. We'll go from there. All right, let's jump in. So, instead of just leaving the inheritance to your kids outright, one option is to leave it in a trust for them and name the child as the trustee of their trust. So let's say the child's name, Truman, I'll say it, kind of sounds like trust. Makes it easy for me to remember. You could say in your will, in your last will and testament, when I die, I leave my estate or, my estate 3 ways to my 3 kids. And Truman's part is going to go into the Truman Trust with Truman as the trustee of that trust. It'll say more than that, but that's the gist of it. Or you might have your revocable living trust in place. You want to make sure your family avoids the probate. Things are titled in the name of your trust. And in the trust instrument, it says, when I die or after me and my spouse die, I name the Truman Trust as a principal beneficiary of my revocable living trust. So your trust, when you die, is leaving things to your child's trust. And again, you're naming your child as the trustee, and there's lots of other trust provisions, but I'm going to kind of focus on that for now. So that's how you do it. What are the reasons people do it? I think, and look, this is an 8-part series. This is just one of 8 parts, so you got to really watch all of them to figure out, the pros and cons of each. But when people leave assets to a trust for their child and name their child as the trustee, it's typically for perhaps some kind of divorce protection. It's, they want to leave the assets to the child, but they want to provide just an extra layer of protection just in case the child gets divorced, after the child receives this inheritance. Because when a child just gets it outright, it's pretty easy for that child to commingle that inheritance or mix that inheritance up with other assets that they have with their spouse, and then they get divorced. Child loses half of his inheritance. But by you setting it up so it goes directly into the child's trust, that really forces that inheritance to be kept separate from the assets that your child has with their spouse. So if they do subsequently get divorced, they keep their trust. Your child and their spouse will split other marital assets, and it just might make that inheritance for your child divorce-proof. You may also, though, another reason people will leave things to a trust for a child, name the child as the trustee, not only the divorce protection, but maybe you want to designate, hey, if there's anything left in that trust when my child dies, I want to make sure it goes on down to my child's children. I don't want it to go to my child's spouse, my child's stepchildren. So you may name your child's children as what's called the principal beneficiaries of your child's trust. Yes, your child may spend it all before your child dies, and hence nothing would go on down to the next generation, the grandchildren. Yes, your child's spouse might influence your child to take it all out of the trust and spend it or commingle it anyway, but you don't want to go so far as to putting somebody else in control of your child's inheritance after you pass away. You want your child to have that, ability to control the inheritance, or in this case, the trust. All right, so the consequences of setting that up, it's all got to be set up through your either last will and testament or your revocable living trust after you pass away, or if you're doing this with your spouse, after you and your spouse pass away. Your child's inheritance will be established in accounts titled not just in Truman's name or Truman and his wife's name. It'll be established in accounts titled the Truman Trust with Truman as the trustee. Really kind of forced to be kept separate from other assets. Now, again, I mentioned it a moment ago, when you're naming your child as the trustee, you're and trying to protect it in case they get divorced. It's not that absolute protection, because when your child is the trustee, your child could be influenced by their spouse or by some other third party to spend it all, take the money out of the trust, and do away with the trust. So that's a possibility. And by leaving it to a trust for your child and giving your child that ability to be able to kind of do whatever they want to with it, you're certainly not protecting it from any kind of lawsuits that the child may have or creditors that the child may have. Basically, if the child can get to it, a creditor can get to it. And when you're naming the child as the trustee of his or her own trust, you're not, providing any kind of lawsuit protection for that child. And for some parents, they want their child to have that protection. Hence, check some of the other parts of my Part 8 series. So this is a scenario where, you're leaving it to your child. You're not restricting your child's ability to spend, use the inheritance, but it's a way to at least, like some parents tell me, let me just set it up for them the right way so my child will have an opportunity to keep it protected. If they want to mess it up, so be it. I'll be dead. I'm not going to worry about it, but at least I'm doing everything I can to try to protect my child and my child's inheritance. So many parents kind of like that idea. I guess they like it because divorce happens so often. A lot of our clients have been divorced. A lot of their children have been divorced, and the parents just they kind of want to do it, and it's never a pleasant experience. So the parents they want to do what they can to just set it up in a way where, life is hard, and any advantage they can give to their children, they like to give it to them. And perhaps if there's something left for the grandkids, that could be a reason as well. Because let's say, when mom and dad die, there's $500,000 of assets in the Truman Trust. And the Truman Trust says when Truman dies, the Truman Trust goes for Truman's kids. And after you die, Truman's wife, who maybe you don't like too much, she grabs Truman and takes him down to the lawyer's office and gets Truman to sign a will, leaving everything he has to his wife when he dies. However, Truman's will doesn't control where Truman's trust goes when Truman dies, if it's set up this way. Now, that's kind of one of the benefits of leaving things to a trust for Truman, is that you get to control where the Truman Trust goes when Truman dies. Again, if you set it up that way. You could also set it up where Truman controls where the Truman Trust goes when Truman dies. Okay, way too much information about Truman that I just gave you. But the idea here is perhaps instead of the outright bequest, maybe a step beyond that is in trust with the child as the trustee. There's extra protections in place there. All right, so I hope that helps. Stay tuned to really get the full effect and make informed decisions. You probably got to watch all 8 parts of this 8-part series, because each one is a different little nuance. Different ones have different reasons for doing it, different consequences for doing it. So, want to make sure you pay attention to that. Like I mentioned earlier, punch that subscribe button, hit the notification bell. I'm going to finish out my 8-part series really